You're listening to KBC English Service.
Children are treasured in Kenya and in the entire world. And, actually, following African tradition, we believe children are a blessing from God. Now, in Kenya, they form a vast percentage of the country's population at 40%. Now, with such a high number, it is therefore no surprise that many children are born out of wedlock or born to parents who are not in a mutual relationship and have no intention of being in one. This leads to situations where one parent, mostly the mother, is left to meet the needs of the child single-handedly. What does the law have to say about children in such a predicament? Do they enjoy rights? And if so, what are these rights? Which of the parents hold a parental responsibility? And what channels are available to redress or to ensure that these rights have been provided, especially for a parent who has been left to shoulder the responsibility of raising the children alone? We are pleased to be joined in this conversation by a friend of the show, advocate of the High Court of Kenya and a law lecturer at the Catholic University of Eastern Africa, Dunstan Omari. Dunstan Omari specializes in children's rights, and we're hoping our guest will also be joining us from the Women Employer Link. Now, welcome to the program.
Thank you very much, and Kenyans, welcome to the fundamental question about children, because that is a succession plan. That is the only way generations continue living. So children are very critical. Remember, you are a child sometime.
Absolutely. We all came from there. We don't just happen to be there. Now, a week ago, social media erupted in a reaction to the story of a woman who had sued a high-profile politician over child support. Of course, we cannot get into the matter in detail because it's sub judice. But, yes, you're the one who filed the gag order. So I don't even know why I'm worried. He's here to help us because Dunstan Omari is the one who filed the gag order, barring the media from commenting about the matter. So it is good that we can get it from the horse's mouth. Now, is it possible to tell us what informed your decision on that matter?
First and foremost, the law about the child is very clear. Section 76, Section 5 of the Children's Act provides that in all matters of children, whether filed in court or anywhere, they cannot be published, they cannot be discussed, they cannot be printed. The names of the father, the names of the mother, the names of the school, anything that can identify that child cannot be in the media. And the penalties provided for that whoever is found to have breached that law in Section 76, subsection 6, will be fined upon conviction, Kenya shillings 100,000, or an imprisonment of 3 months. So by law, it is prohibited. That is the international standard when you look at the United Nations Convention for the Rights of the Child, when you look at the African Charter for the Rights of the Child, when you look at Article 53 of the Constitution, when you look at Section 4.3 of the Children's Act, it provides that the best interest of that child
must be upheld.
The reasoning behind is that when you discuss about that child is stigmatized. That child does not live a private life. That child becomes a subject of ridicule. That child becomes depressed. So the law must protect the privacy of children when it comes to issues concerning court matters.
Now, on that note, when we talk about, children come into various relationships.
Yeah.
The ones that are in a recognized matrimonial union already are well factored in. What happens to these ones out of wedlock? What rights do they have?
Before the enactment of the Constitution of Kenya 2010, there were two types of children.
Right.
Those children were, I'm talking of children whose parents are alive. Then we shall be talking about children whose one parent or the father has died.
Right.
So that is now inheritance. Let us start with children born in wedlock.
Yes.
The children born in wedlock and the children born out of wedlock are the same under the law.
Yes.
In terms of maintenance. Before the coming of the Constitution, Section 25 of the Children's Act provided for that those children will be taken care of by the mother at the first instance. Because at that time the position of the law was that children must be born within a marriage, and it was the mistake of the mother that a child was born outside wedlock. That was the position
before
the coming of the Constitution.
So after the promulgation?
So after the promulgation of the Constitution in Article 53 1E, Wanjiku and every Kenyan said that every child has a right to be protected by the parents on equal terms, whether married or not married. And I want to repeat that for the whole nation. Article 53 1E provides that a child will be provided for and maintained for by both parents, whether married or not married. By that, we have now removed any child who is called, this is born in a marriage, this is not born in a marriage. So as we stand here today from where I sit and from the position of the law, and that is the Constitution, every child will be accorded protection and maintenance, whether the mother was married or not. So that's the position of the law.
Okay, so at least we've said now they're both entitled to being taken care of, and it doesn't matter whether you're living with your mother or the father.
Yes.
Now, of course, we have seen an increase in the number of women, pursuing the rights of their children born out of what we were calling wedlock before.
Yes.
And you have clarified they're now on equal rights.
Yes.
Now, does it therefore mean that if a woman conceives a child out of a one-night stand situation, that the child has equal rights to these others who are in a planned relationship?
The children born of any woman or any man are equal.
Okay,
Section 23 deals with children as equal children. In Section 94 of the Children Act that provides for maintenance of children, the question is you cannot discriminate one child against another.
Perfect.
So if this child is father, is a president, is a deputy president, is a cabinet secretary, is a lawyer as senior as me, that child who lives, and I live at Karen, the other woman who I will have a child with, that child cannot live in Kayore. The law talks of a comparative approach to children. So children must live on equal terms. You cannot separate it. Therefore, all the children will live on the same lifestyle. The Children's Act and the Constitution deals with children on equal basis. So there is no discrimination that this one was born outside wedlock, this was born in marriage. All of them are children and they will be protected the same way.
Now, another important and very crucial part of a person's identity is the issue of name.
Yeah.
So last year, Justice Mombi Goge ruled that all children born out of wedlock have the right and liberty to have their father's names entered into their birth certificates. Does this mean that before this ruling, I could not include, for example, if it was me, the father's name in the child's certificate without their consent?
Under the old regime, under the Registration of Births and Deaths and Births Act, if a child was born outside wedlock, the consent of the father was mandatory. That is why the mother had to produce a copy of the father's ID if there was no marriage certificate. That was the law at that time. Coming to the Constitution of 2010, it became very clear that now a father, whether married or not married, is a father for that child. Because children are not born in marriages. Children are born in an act of sex.
Absolutely.
Whether it is in marriage, whether it is not in marriage,
matter.
whether it is in prostitution, whether in any matter, the law does not care the circumstances of the conceiving. It matters that the conception has taken place. So Justice Mumbi Ngugi put it very clearly that now it is automatic. If you are the biological father, the name of the child, the name of the father becomes part of the name of that child automatically. So that's the position of the law.
So we're going to take a short break for the news headlines, but when we come back, we're going to look about the element of mischief, because sadly, human beings, we all have sikilam to straight. So definitely keep it locked. Of course, we have with us Dunstan Omari. He is advocate of the High Court of Kenya, lecturer at the Catholic University, and we're looking at the issues of children. What are their rights? As he's explained, there is no child born out of wedlock. The child is born out of conjugal practices. Therefore, all children are equal under the law. Send in your comments on 22162, beginning with the word English. Straight back into our conversation. In studio, we have with us Dunstan Omari, advocate of the High Court of Kenya, lecturer at the Catholic University, and we are discussing issues of children's rights. Just before the break, we were talking about a ruling made by Justice Mobi Goge that said all children born all children were entitled to having their father's names. And now we move on to the next question. Now, a number of men raised issues with this ruling, and their concern was cases where women used false pretenses to cash in on such circumstances by putting in a man's name on the birth certificate and using that as proof of paternity. And of course, these concerns are valid. What was the redress for such a matter?
The question about women cashing in is not there. The law is already settled. Any claim can be determined scientifically. So there's a question of DNA testing. Remember, in court, a birth certificate is not conclusive. It's not conclusive for paternity. If you dispute, the courts are very clear to order for DNA testing. And out of the urgency and the issues of DNA testing, government reduced the cost of doing DNA testing. Now at government chemists, it is merely 14,000, 15,000 to do a DNA testing.
Who pays for it?
The law is very clear. The man will pay if he has means. If the results come negative, it will be refunded. That is settled by the law. So there is no question about anybody fearing that it will be a question of gold diggers. Any dispute of paternity will be determined scientifically. So let nobody complain over that.
Okay, and we are joined by Peter Gichanga from Women Empowerment Link. Good morning.
Good morning.
This is going to be an interesting conversation. I have men fighting for women's rights, and I thought, so I will have to be the single female voice in here. So, Karibu Sana, we are discussing, of course, the rights of a child, and thanks to Wakili Omari here, he's clarified that under the new constitution, there are no children born in or out of wedlock. All children have the same rights. They're supposed to be provided for by both mother and father.
Yes.
That is where we are at the moment. And we're talking about Justice Mumbi Gogi's decision that said all children should bear their parents' names. So now we need to know, this same ruling does state that the father's name is inserted in the birth certificate. He, the father, must be issued with a notice of intention to do so. Isn't that the same thing as seeking consent?
Yeah, it's like seeking consent, but at the end of the day, he's the one who is responsible.
So how has it changed from the woman having to go to produce a photocopy of the ID to say that this is the father of the child? Have we improved anything there?
In the first place is that for a child to be born, there had to be two people.
Which he clarified. We said actually a child is conceived out of sex, not out of a relationship.
Out of sex,
So our concern here is, initially in the previous, under the old constitution, a mother had to take a photocopy of the ID of the father to prove he's the father. Now under this one, we are saying, I still have to take a letter of consent. Like we said, human beings are prone to mischief. Somebody can decide to just say no because they can say no. So what proof, what will I have on my end? And Wakili has said we could, in that case, we go to court and demand a DNA testing. So there's no other way.
What I'm telling Kenyans is that the question about DNA testing is very, very cheap. Government has reduced the cost of DNA testing.
To some of my listeners, 14,000 is a lot.
14,000 will be paid by whoever is denying. That's what I'm saying.
Okay.
If the mother says Omari is the father, and Omari is claiming I'm not the father, she will move to court. The cost of filing a children's matter is around 470 shillings.
Okay.
It's as cheap as that. And that, the court will order whoever is denying paternity to move to the government chemist, pay for that, and if he's found not being to the father,
then the mother will have to
refund that money.
So
it is as cheap. The question before people is this: it's not about the mother, it's not about the father, it's about that child.
Right.
And that is the best interest that people should understand, that the courts do not protect the father, the courts do not protect the mother, the courts will protect that child. And the courts have held that the child has a duty to know who is his father, who is his mother. So that is the position of the law.
Okay, I think that is good. Do you have anything to add there, Peter?
Yeah, that's about identity.
Right.
And that's why you have a lot of people, we have a very hostile generation, whereby somebody does not know his identity. So at the end of the day, it's her right and his right to have the identity.
Yes, we mentioned the crucial part of a sense of belonging.
Yes.
Roots.
Yes.
Roots are a huge thing for any human being.
Yes.
Now, let us get to the sticky issue of something called maintenance. Now, that's the one thing that that stands out in such cases, Dunstan. What, according to the law, does maintenance mean?
Maintenance means on 7 things. 1, the right for a parent, the right for anybody who has a parental responsibility, whether you are the biological father, whether you are through adoption, whether you are through a guardianship order, anybody who has parental responsibility, whether you have acquired parental responsibility. You can acquire parental responsibility under the law in these terms. If you marry a woman and you support that child for 12 months,
yes,
that child is yours.
Adoption.
You have acquired parental responsibility. Yeah. If you maintain a woman as your wife for 12 months, you'll have acquired parental responsibility over those children. So that is a person called a parent. Then what does the parent provide for the child? One, a parent, as I've defined who is a parent, will provide for education and education-related expenses. School fees, boarding, uniform,
books,
textbooks, all those things. Number 2, that parent will provide food. That parent will provide medication. That parent will provide clothing. That parent will provide shelter. That parent will provide utilities in terms of electricity, water, and all those things. That parent will provide for care, which includes, if the child is young, a house girl or a house boy. That if it is a big compound, what is called security. That parent will provide others depending on one issue, ability. For example, if this child, before people differed, this child used to go to holiday in Masai Mara, in Mombasa, the parent will be told to continue providing those holidays to Hawaii. If this child used to go to school in a V8, the court will insist that that child will continue getting what it used to get before the father and the mother differed. So the question there is, maintenance is based on the actual needs of the child and the former lifestyle that this child was introduced to. So that, and also the comparative I said, what other brothers and sisters of this child are having. If other sisters and brothers of this child are living in Karen,
yes,
then this child will also be removed from a slum in Madare and be taken to Karen.
But now
that is the position of the law.
Okay, now as a mother I have come in, I'm feeling threatened. Are you going to take the child alone, or am I going with my child?
The law has been settled in Jamong and Jamong in the Court of Appeal decision that the mother being the one giving care, this child cannot go to stay in Karen alone. So the mother is a beneficiary because it provides for this care. So the mother will be there. But the law is, it's not the mother who has been housed.
It is the child.
It is the child. The father has housed his child.
In the standard of the other siblings.
That is the position of the law.
God protect us from mischievous people.
That is the position of the law.
I can see people scheming and planning right now.
No. You have an option not to give birth to a child. No, the law is very clear.
Wait, before we get there, let's see what Peter has to say.
But actually, that's not a reality on the ground. You find a mother with her children going to court, to the children's court.
Yes.
And what happens? She comes in a matatu with the children, and then the father comes with a V8.
Yes.
Then what do they do? The case is postponed. The mother goes back home.
And the case is take forever.
Currently in Kenya,
yes, it
is not a reality. Because the law is, but at the end of the day, it's a burden on the mother.
Let me differ.
But honestly, maintenance matters.
The position of the law is very clear. If you go to court and you ask for what you want and produce evidence that is the position of other children, the court has no other alternative. That is the court that was there before the coming of the Constitution. The Children Court under Section 73 of the Children's Act is so powerful. The problem, and Kenyans who are listening, is that the mothers don't have no civic education. to know what their rights are.
And also the means, because let us be honest, children matters take a very long time to determine.
They don't.
That is true.
From my experience,
Very
I can
true.
say they take a while.
They don't.
It also depends on who has filed. When I have Dunstan Omari, well known. People already, Gina inatisha watu, things will happen.
When you get to the point now of...
You see, for example, he got a gag order for someone.
Yeah.
So we cannot even say names.
Yeah, you
but
can-
if you have a regular, either a person who was just admitted last week or whatever, they don't have that clout. And you see, like you said, one, she's ignorant, this woman. Two, society has already decided a woman going to court, in most cases, she is an opportunist, a gold digger, she's trying to cash in. So there's also that, she's not very sure what her rights are.
And also when you look at the systems in Kenya, the burden of proof is very heavy.
On the mother.
Yeah. And the benefit of doubt, the man just walks in a suit and tie, he has the benefit of doubt. But the woman has to prove the case as he's putting it. But proving that case now, that platform is very, very uneven for women.
Let me put this very clearly to people. Stop the narrative that women have a challenge in courts. Those courts are so friendly to children. Anybody who walks to a children's court today, there are only two questions the court wants to know. Is there any document to prove that there is any
paternity of the child?
There's a copy of a birth certificate on the spot under Section 98 of the Children's Act. The court will give interim orders for fees and school related on the spot. The first day you file your case like this, the court it's mandated to give fees and school related.
I like what you're saying. You see, the court will give orders. Enforcement is the challenge.
Let me tell you about
I will give a simple example. Let's not even go to court. Sometimes people start by going to the children's officer,
Yeah,
Sindio,
that is right, it
at
starts.
county level, at district level, and you're like, this man, they sit down and they agree, maybe you shall be bringing 5,000. In fact, there's so much animosity, the children's officer is like, bring it to me.
Yeah, it goes through the
Then these
children's
people do not even actually pay. Where is she supposed to go? If he comes and says, I don't have money, nitafanya nini. I have been involved in these cases. That's why I'm speaking from experience.
For the benefit of everybody, I was a very senior children's officer before I went to do law.
See, that's why I told you, they hear Dunstan Omari, they take off.
So the question is very clear. Under the law, questions of maintenance are not supposed to be handled by the children's department.
It is being done.
I'm telling Kenyans the truth. Under the law, a mother will walk to court directly.
Should walk to court.
Because the question is there, the children officer has no enforcement mechanism.
He has no powers.
He cannot enforce what we call under Section 26 a parental responsibility agreement. But if you walk to court, and I'm telling you, under Section 27 of the Children's Act, of the Constitution, the question of children is a fundamental human right.
Absolutely.
And you can walk to court without even papers and raise up a hand like this. The court will listen to you and grant the order.
How do you move the court?
I've told you under Section 27, questions of fundamental human rights. Justice Lenaola has put it very clearly that if a mother walks to court and the court has a duty to listen to that, what the mother wants. Let me tell you, it is only the children issues that have a huge group of people who can represent children. We have Kituo cha Sheria,
Yes.
we have Cradle, we have
Koba,
Nale, we have so many. Under the Law Society of Kenya, as an advocate, if a woman, if a mother, if a child walks to the Law Society of Kenya branch, the whole country, we are mandated to represent women on pro bono basis. It is only that people don't know the rights of this, and under the access of justice, that is the bill that is in Parliament now, it is being made compulsory that every lawyer must represent a child before he gets a practicing certificate.
Thank you, and that is what I'm happy about. You see, the Bible says, my people perish.
Because they don't know.
And that is the biggest fact and
And
the
I've
biggest
told them
challenge.
today.
Thank you, but they did not know. So people will always try and find resolutions within their hands. Or what is your experience, Peter?
I'm looking at that woman in Mathare, or somebody who is in Kasipul Kabudo. by the sight of that emblem, the coat of arms, they shrink.
Yes.
So at the end of the day, who would get this particular woman to move to court? And still, the issue of feeding these particular children. The children slept on an empty stomach. She now needs to come to Nairobi, or rather to the nearest court. That movement is a real burden to women.
Under Article 48 of the Constitution, we are talking about access to justice.
Right.
The judiciary is transforming itself to take the courts back
To where they should
to the
be.
villages.
Okay.
So it's not a one-off progress. Under the Mutunga regime, under the Maraga regime, courts are going down. Two, under access to justice, the procedures in courts are being simplified.
Yes, that has begun with already.
It is already very
Probate.
clearly
With probate
that,
already,
that
that
we
is
are
what
now
is-
simplifying the procedures.
Yes.
That's why I'm saying that progressively access to justice is going down to everybody. The only challenge that I have is the people who are getting money through the NGO system, through the civil society, with a view of giving these children empowerment. I wish the partnership, like now, it is the only radio show that has brought me on board to educate the people. With this and the mass media going all over, then we are protecting the children. Let us not only look at what government can do for the children, let us also look at what professionals, what the private sector, what the civil society,
Excellent.
what Kenyans can discuss. Because as I've said, issues children, it is the generation that takes over leadership. It is the generation, all of us will be dead, our children will take over. So it is such a critical issue. No country develops without protecting their children. When we talk about crimes, there's crime at the police, is because the children were not taken care of.
Okay, so I think, if you're just joining us, we have with us Dunstan Omari, advocate of the High Court of Kenya, the man who put the gag on us, so we cannot discuss things. We also have with us Peter Gichanga, who is from Women Empowerment Link. It's interesting when we have men discussing women's issues, I tell you.
No, we are not talking about
in a
women.
nice way,
It's about
children.
Only children.
What?
Yeah.
Guys,
The discussion here is
peace,
children.
Peace on earth. Here we are discussing children's issues.
Good.
And it is Angie to Tetea herself and everyone else. But in the meantime, so in brief, what is good news for me is a child matter. All you need is 425 shillings.
Around 425.
Let's just say 500
around
shillings
500
to file
a matter in court.
To file a matter, you now hear there is the access to justice bill going through. Therefore, matters will be easier. The issue of paternity tests. Once you have filed your case, you hear the court will order a paternity case, and the person in dispute, if it is a man saying mtoto si wangu, he will have to pay the money for the DNA testing. If it is found out that Angie lied and the father is not Omari, I will have to refund the money.
Definitely.
So at least we're trying to make an
But
even playing field.
you'll be surprised that women are not mad to claim on somebody.
Oh, definitely.
Because when they know it's going for DNA testing, they'll run away. It is rare that a woman will just walk. Women have their own dignity. Mothers have their own dignity.
Thank you.
How do you just walk and claim this is the father of these children? It is never possible.
So that was a brief summary, but now let's get into this issue. So Wakili Omari has explained that the court will decide, yes, if the father is, I'm going to use Omari because it's appropriate, if he's living in Karen and the children have been going to Masai Mara and everything, Angie and her baby will have to move to Karen as well. We shall live the same lifestyle. But now here's also a challenge. Sometimes the child has, the child having a right to joint provision by both parents. So what happens in a situation where, fine, you are able to take care of things, I am not, or you lose your job, what will happen to this child then?
The law is very clear. It is equal parental responsibility.
So does that explain that?
I want to explain that terminology. Mothers have been lied to that the role of providing for children is a father's role. It's no longer that. You will provide for your child, subject to ability.
Mm-hmm.
That is the provision of Section 94. Subject to ability.
Right.
It is already a settled principle in law that fees and school-related expenses is normally to the father.
So usually
that is already settled
in law.
Up to the Court of Appeal that in fathers take care of fees and school-related expenses.
So what do I take care
Then
of?
the rest now, it depends on ability. For
Okay.
example, if the mother is employed and is paid house allowance, she will provide shelter.
So she can pay for the rent.
She will pay for it.
Okay.
If the father is employed and there is a medical cover, he will provide medical cover. And if the mother is employed, both of them will provide medical cover.
All right.
Then under what is called the affidavit of means, which provides for the financial responsibilities of the father, the financial responsibilities of the mother, the court then will decide what the mother will pay for the other remaining items and what the father
So like
will
a declaration of wealth.
there is it's like a declaration of wealth and liability. And lastly, in the court takes cognizance of these following. One, the mother provides care and the nurturing.
Which you can't put value to.
It has a value.
How much
and
is
the
it?
Courts worldwide have looked at, in the totality of the child's expenses, 30% the mother provides in terms of cooking, in terms of washing for these clothes, in terms of being
Just
there
attention
at
to
night.
the child.
30% of the value. So what the mother will pay will be less,
30%.
almost 30 to 35%
Okay.
from what the father provides.
All right.
That is what is called the principles as provided for in terms of maintenance of that. And the courts have said that, and the law is very clear, if the mother has nothing, and you knew very well that by the time you were entering into a relationship and giving birth to a child, you knew very well that this mother had nothing, and you continued to provide for this child wholesomely, the court will tell you, continue
Endelea.
doing what you have been doing. Don't start raising that question today.
So Peter, what has your experience been?
The law is very clear.
Right.
But what you're saying is that to get to that level of now arguing it on the court platform, it has been an issue to the mothers. But at the end of the day, what you're saying is very true.
Right.
If my wife is providing for the family,
Yes.
when we get to a point of differing,
Yes.
then she'll continue
That's
taking
the
care
law.
of the two of us.
Okay.
Like as in before, when women were just going for men, you called them gold diggers.
Well, the scales have
So
balanced
the scale
now.
of balance now. It is
Okay.
equal to a woman should also continue providing for the man and the children, if she's the one who is doing it currently.
Now here's a question. I was with him. Fine, I was the sweetie on the side. Tumeachana. If I remarry, does he still have to take care of that child?
No.
I'll tell you the position. The father of a child remains the father of a child even when dead.
Okay.
It is the woman who has remarried.
I'm the one who has gone.
The child does not move from being my child
Right.
to his child.
Okay.
That is the settled point of law. Under section 24 and 25, it is very clear that not one parent or two can continue to. So you can have one father. We can have one child being maintained by 10 people. That is the law.
Fine.
That is the
good.
law.
Now that adds
It is the woman who has been married.
Not the
the child,
child.
still remains the child of the father.
Until the age of 18. When he can
that's the
make a
part I
consent.
wanted to clarify now. When the child hits the age of majority,
Aha.
you see, not everybody becomes automatically 18 and independent.
yes.
There's campus, there's
Very
other
well.
things. What happens there?
Section 28 of the Children's Act talks of extended parental responsibility. If the child is 18 and that child is still in school, or that child needs medical attention, somebody will move to court under Section 28 for what is called extension of parental responsibility, and the court can extend with an application being made, or the court itself, without anybody telling the court what is called the principle of suo motu, it will extend that child. A case called Kibebo versus Kibebo is very clear that a child went to school, finished and went to law school. Law school, the university for law, that child is 19 years. That child finished a degree, was going to the School of Law, Kenya School of Law. By the time the child was in the School of Law, he was 27, 28 years. The court extended parental responsibility. So for the purpose of education,
That will
a
happen.
child will be a child until
They're done.
until the education system is over. So it does not matter the age.
Excellent. Now, there's an issue that sometimes comes and is very sticky. The issue of child custody. Yes. So what do we do about that? You know, in some cases you will hear they say children legally, children under the age of 11 belong with the mother, unless of course you can prove she's incompetent.
Well, Section 83 provides the law, the principles to be considered for custody. Let me tell you what you are telling is what was
In the
originally
previous
called the tender year principle.
Yes.
That custody of children of tender years who are 11, 12 years lower were going to the mother. Today the law is very clear. It is the best interest of the child. Who between the two
Is the best person to be with.
Although courts tend to believe mothers to be the best provider, there are mothers who are helplessly hopeless. They will be denied custody. So
Upon
the law looks at the child.
Yes.
For the benefit of Kenyans, the children's law looks at the child. It does not look at the mother. It does not look at the father. Section 6 provides that if the mother and the father are hopeless, a third party, the child will be snatched from a mother and a father and given to a different person under Section 6 to take care of that child. So the law looks at what is the best interest of the child.
The reason why I have brought that question is because sometimes when women have children with people who have great authority and names, the threat is, I will take them, you will not have them. I have dealt with people talking about those issues.
They have had it very clear.
I am glad we had this opportunity so that we can encourage people to be able to speak out. Now, what is, so we've said at least the court will look at who the child is best suited to be with. How is the reality on the ground? Now Dunstan having the experience of being a children's officer and the kind of man who gets gag orders, he's working on the right side. He can go to the High Court, Supreme Court.
Yeah.
Your average 190 even get into the RM's court. The children's court is a challenge. What is happening down? Let us talk about what is happening to Wanjiko.
It's a big challenge, as I've said. One, they have no civic education. To get to them is, and we also get to a point whereby the church has failed completely, because that is where, according to a survey that was done in 2004 by Nairobi Main Hospital, is that if a child is abused, the first person to go to is a pastor. And where I sit right now, I have 3 cases of pastors who have abused children. So at the end of the day, who takes care of these children?
Well, yeah, we've had religious leaders being implicated, but it's also this. You brought in an element that we had also considered. That when women are aggrieved and you're feeling stuck and where to turn to, we don't think of the legal system first.
Yeah.
I'll either go to my reverend, why mimi nimeteseka sana. Then he tells you, leave it to the Lord, my sister. The Lord will justify.
Actually, we normally say that when the woman goes to the pastor, she goes with the issue of her husband being an abuser, but at the end of the day she lives with her another name, that is a devil. That is a devil in your house, ABC, DXYZ, and then they start comparing
the Satan in him.
Satan in him. So at the end of the day is that when now we talk about the law, which is very clear, and actually we have the best Children's Act in Kenya.
In the world, well, in the country,
but
in the continent.
The problem in Kenya is that we have very, very good policies, but they are all gathering dust at the government.
So enforcement and enactment is a challenge.
That is a problem.
But I think today people have been given knowledge is power.
Knowledge is power.
Tumeanza.
Yeah, tumeanza.
Definitely tumeanza. Our final question on this matter is the issue of inheritance. Sadly, and it's the reality of Kenya, when a big name goes to the great beyond, people appear from nowhere, and some of them you don't even have to ask where they belong. You just see photocopy. But we didn't know. So now the issue of inheritance. You see, now at least if we'd started earlier and the parents there was maintenance and everything, there's proof. And my friend here again was in a similar case, where we were like, this child has rights. What happens then? You see, because now paternity becomes complicated. We're talking about having to exhume and everything else. What happens to the rights of this child?
I like what is coming out these days. When somebody comes out in the light, when somebody is being buried, then stop the burial, ABCD, the family goes back and
wanaskizana.
And when you talk about issues of continuity, there's like I remember some 3 cases recently, whereby somebody comes out and it's like I've been assisted up to this point. Then if at all I'm not going to get into the system, the burial should stop until we agree. And people are agreeing. Because at the end of the day, there is an issue of communication. These days, it's not about giving money hand to hand. It's about M-Pesa. So if you can prove that you've been receiving money, it has to continue.
There's proof, but yeah, what is the way forward, Omari? Because we also don't want to be just doing things by threats.
The law of succession is very clear. The law of succession is a law that deals with the property of a dead person. You do not invoke the law of succession until the parent is dead. Mm-hmm. So there are two types of death. One, there is where death, somebody by dying writes a will.
Attest it, yeah.
And there's when that person has not written a will. Let us deal with the first one. There's a will. Mm-hmm. And this will has given so and so property and left one child out.
Yes, you did not name mine.
So under section 26 of section 26 of the law of succession, that child who was left outside will move to the court and demand for reasonable provision. Mm-hmm. And prove that at the time this man was alive, he was supporting this child.
What if he was not, but this is the child?
If there is evidence that this is his child, either by evidence that he was supporting this child or by scientific evidence that he was supporting that child, the law will disregard that will and provide for this child. Mm-hmm. And for the purpose of succession, the mother of that child will be declared a wife for the purpose of succession. Mm-hmm. Not a wife for any other purpose. For the purpose of succession, that mother of that child will also inherit. Mm-hmm. Number two, suppose there is no will. This person has died intestate. The law is also very clear. If this child was a dependent, and the definition of the dependent is very clear. Anybody who was being supported by the deceased immediately before he died, whether it is a relative, whether it was a worker, not salary. If it was a cousin, if it was the deceased's parents, anybody who was dependent on the deceased, not on an employee relationship, will be declared a dependent.
Okay.
So that is the position of the law. They will, so no child should be dispossessed the property of their fathers. So the matters that you deal from maintenance of children in the children's court escalate to succession matters when that father is dead.
Okay.
Let me also bring a very interesting angle to that issue. Suppose people go to court to stop burial. The courts have now held that you do not stop burial.
Yes.
DNA testing can be done from those who are alive.
Okay.
The only time courts are now stopping burial is only on two grounds. One, the land is in dispute, where the grave will be. And two, one of either the child or the wife is being excluded from participating in the burial.
Okay.
Those are now the two settled grounds where burial disputes are, the courts are intervening. So it is now settled. If you want DNA testing, his sons are here, the siblings are here. We do not want to stop that. Or during the DNA, when they are doing postmortem, they normally remove some samples to be kept aside for DNA testing. So that is the position of the law.
Excellent. So, well, I tell you, time when you have serious discussions just flies. In studio, we had with us Dunstan Omari, you've had his reputation. So, advocate of the High Court of Kenya, special person in getting gag orders, a lecturer at the Catholic University. We also have with us Peter Gichanga. He's from the Women Empowerment Link. This was, I think, the tip of the iceberg. The conversation will continue, but I think we now are empowered better. And yes, we need to remember when issues concerning children, the court considers the rights of the child. So it's not about politicizing or creating awareness about yourself or shaming someone. The court considers children.